So what everyone seems to be missing is currently almost at every school district, there's a policy called AR 5145.3. And this policy requires that schools keep a transgender student's transgender identity secret unless the student says that it's okay to reveal it. So it is the child that is making the decision. The child who could be 4, 5, 6, the child who could be suicidal, the child who could have other mental health issues. The child is the one dictating whether this is revealed. However, everyone at the school knows, except for the parents who are the only ones who are able to keep them safe. And Aurora's daughter was told by the school to lie to her about her transgender status, to lie to her own mother. That's what happens at the schools.
Just to address, Senator, your question about the Attorney General statement in the Mirabelli case. So the Attorney General did say that the guidance issued by the California Department of Education is not binding, but that's true of all agency guidance. What the Attorney General did say is that the law that underlies the guidance, California's anti-discrimination law, California Constitution, that is what is enforceable. The Attorney General has issued a clarification to say that specifically, and so it's not true that the Attorney General has said that the CDE guidance is not enforceable.
Briefly, Ms. Friday.
They have said it 4 times. I have the court documents that the guidance is guidance and it's not mandated by law. We need to talk about actually what the Constitution permits. Is there a privacy right between a child and a parent? Do children have a privacy right against their parents? They do not. And that's what the federal court said in the Mirabelli case, is that as between parents and children, there is no privacy right. So that is the Constitution of the United States. Also, the 14th Amendment provides that parents are get to care and custody and control of their children. So this law is unconstitutional as written. And this statement in the bill that says this is just declaratory of existing law is a falsehood. I would love for the author to talk about what law it is actually that permits and requires schools to lie to parents.
The Chino Unified School District does have a policy that is both on sexual orientation and gender identity.
Chino policy requires that it is actually under an injunction at the moment, but when it was put into place, it requires parent notification if a child asks to use a restroom of a gender other than what they're on their birth certificate, if they ask to play on a team, and also if they ask to use a pronoun or a name in their official or unofficial records. That is how the policy reads in Chino.
Because I wrote the policy. I wrote the parental notification policies. So the parental notification policy for Chino Valley does not touch on sexual orientation at all. None of them do. I wrote the majority of them. They all deal with whether a school is participating in the social transition of a child. So when a child asks the school to change their name, when a child asks the school to call them different names or accommodate them by permitting them to use different bathrooms or a different sports team, it does not cover where a teacher hears that a child is transgender. There's no notification requirement whatsoever. It's only if the school participates in the social transition, which is a psychosocial medical intervention for the child.
Appreciate that.
This is not the way to find out, because no matter how we feel as parents, the fact remains that when you forcibly out a child, it harms them. That's it. This is harmful.
So privacy is so important to understand. For a privacy right to exist, there needs to be an expectation of privacy. That's first and foremost. When a student tells everyone at school and all the teachers and all the administrators and all the students know that the child has taken on a transgender identity, then that privacy right is lost. It's gone. And the only person who doesn't know about the child's transgender status is the parent. That is not called a privacy right. and it is not permitted. So there is no privacy right when a child tells everyone, and that is true with sexual orientation too. There is a case from the appellate court that says once the student talks about their sexual orientation or private issues, and they've publicly announced it to the entire school, it is no longer private. So when a child tells everyone at the school to call them by a different name, use a different pronoun, treat them differently, that privacy right is gone. And the federal courts have found that to be true.
Question as it relates. So under the Federal Family Educational Rights and Privacy Act, parents have an absolute right to access any and all public records related to their child. So under FERPA, would parents be entitled to access information regarding the child's gender identity and pronouns?
Yes, under FERPA, they have access to school records.
What FERPA and the way it works in the real world, because I am a licensed attorney, and so when my daughter came out as a transgender child, I did a FERPA request to test the school to see if the school would lie to me one more time. I requested under FERPA all of my daughter's records, and I knew that they were calling her by a male name and using male pronouns, and I did not receive one of those records. And I work with hundreds of parents, and I tell them to send the same FERPA request, and they know that their child is being called by a different name, and they never get those records. I guarantee you, they never get those records because they create a secret file that is held in a administrator's office. So they keep that information secret from parents